People of the state of Michigan versus Abdallah Agber, file number 23-00903. FY, counsel appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
And thank you, Your Honor, and good afternoon. Jared Austin appearing on behalf of Mr. Agaberry, standing present to my right.
How are you, Mr. Agber?
Good.
Okay, today was the date that was set for a preliminary examination, and my understanding is that the necessary witnesses have failed to appear.
That's correct, Your Honor. People are unable to proceed to preliminary examination.
How do you want to proceed, counsel?
Your Honor, at this time, I would ask the court for a dismissal, understanding, of course, the dismissal is without prejudice, and I have explained what that means to Mr. Agaberry.
Mr. Agber, your case will be dismissed without prejudice. Do you have any questions for the court about that?
Your Honor.
Okay, we'll get you a copy of your dismissal in just a moment. You can have a seat.
Thank you, Judge.
You're welcome. On the record in the matter of the people of the state of Michigan versus Alexis Brown, file number 20-01777, counsel appearance.
Prosecutor Paige Petrosky on behalf of the people.
And good afternoon, Your Honor. Brown. Stephen Mills on behalf of Ms. Brown, she is coming in. Ms. Brown.
How are you, Ms. Brown?
Good, how you doing?
Well, thank you. Today's the date and the time that's scheduled for a plea. Was there an offer in this matter?
There was, Your Honor, and it's my understanding that Ms. Brown will be accepting the offer. Our offer is for her to plead guilty to an amended count 1 of larceny less than $200 with a Killebrew agreement to no upfront jail, and the people have no objection to heightened.
Your Honor.
And is there restitution?
There's no restitution in this case. And the people have no objection to immediate sentencing if that's what the court wants to like.
Is there a victim?
The victim in this instance was the bank.
Okay. And that's how you want to proceed? You want to plead guilty to the amended charge of larceny less than 200 today? Raise your right hand. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury. Thank you. Put your hand down. I have an advice of rights and key information sheet. Is this your signature? Did you read these rights?
Yes.
Do you understand the rights listed here?
Yes.
And do you have any questions about these rights? You're willing to give them all up today in order to plead guilty to the amended count of larceny less than 200? You understand that you have the right to the presumption of innocence. So you're innocent until proven guilty. You have the right to proceed to a jury trial and require the prosecution prove each element of the charge being brought against you beyond a reasonable doubt.
Yes.
You have the right to remain silent at trial and not have silence be used against you, or you can waive that right to silence and testify if you'd like. You have the right to subpoena witnesses to testify on your behalf at your trial, and you have the right to cross-examine in court any other witnesses called to testify against you. You understand that? Those are all rights you're also willing to give up today?
Yes.
Anybody threatening you to get you to give your rights up?
No.
Has there been any promises made to you in exchange for you entering a guilty plea today?
No.
Are you currently on probation or on parole?
No.
You understand that a guilty plea could result in a conviction that you may need to report to your current employer, or you may need to report this to it on a future job application.
Yes.
It also could impact travel or immigration status that you may be seeking.
Yes.
As to the amended charge of larceny, less than 200, how are you pleading?
Yes.
And is that because you believe you're guilty?
Yes.
Factual basis.
Thank you, Your Honor. Your Honor, if it's okay, and if the prosecutor doesn't object, I'd like to do it under the original fact pattern.
No objection.
Just regarding the UNP, Your Honor.
Proceed.
Thank you, Your Honor. All right. Ms. Brown, as we kind of talked about earlier, I'm just gonna ask you a few questions here, okay? All right, so on or about February 13th, 2020, at or near 200 East Jolly, Ingham County, were you at a bank at that time?
Yes.
Was that Michigan State Federal Credit Union?
Yes.
And at that time, did you present a check as true to the bank?
Yes.
And you, Alexis Brown, you were the payee on that check, or you at least endorsed that check, is that right?
Yes.
And it was your intent to cash the check, is that also true?
Yes.
And you learned, or you knew that the check was forged, is that correct? Well, you knew or should have known that the check was forged, is that fair?
Yes.
You did not have a right to have that amount of money, is that also fair to say?
Yes.
Okay. Your Honor, if that would suffice, thank you.
Questions from the prosecution?
No, Your Honor, thank you.
The court is satisfied with the factual basis. I'll accept your plea. I find it to be freely, voluntarily, and intelligently made. No objection to immediate sentencing, so you can make allocution.
Thank you, Your Honor. Your Honor, at this time, while we recognize and hope that she will be an applicant into the HIDA program, Your Honor, I'd be asking for a non-reporting probation in this matter. The big reason for that is because this is a 4-year-old case. She has proven over these last 4 years that she's not gotten in any trouble, that she's doing well. She's a single mother and has really been applying herself. She's done a lot of growing up since then, Your Honor. And I think that's really impressive in this matter. She understands what she did wrong. She's accepted that right away, and that's why we're here right now. She wants to make sure she's moving forward and doing the best that she can for her and her children, Your Honor. So for those reasons, I believe in this situation, the non-reporting probation would be appropriate.
Does your client want to make a statement?
Actually, Sean, here.
So, Susan? Okay. Off the record, I don't have her criminal history before me, so I have to review that before I can sentence her. So I'll call your case back once he has to go get it from me, okay?
Very good. Thank you, Your Honor.
Off the record. On the record, in the matter of the people of the state of Michigan versus Marvis Jones, file number 24-00473, counsel appearance.
Prosecutor Paige Petrosky on behalf of the people.
And this is Defender Scott Nick on behalf of Mr. Jones. Present in the jail.
Mr. Jones, can you hear us?
Yes, ma'am.
Okay, today was the date that we reset this for a hearing on the bond because we hadn't received a bond report. I do believe we received one yesterday or the day before, and I'm assuming, counsel, you both got a copy of that.
That's correct, Your Honor.
Yes, Your Honor.
Okay, defendant's bond is currently set at $500,000 cash surety, and he's being charged with assault with intent to murder, weapons carrying concealed weapons, felony, firearm. According to the bond report, he doesn't have a prior history of failure to appear that would qualify as a risk factor for the purposes of his bond. And his assessment scored relatively low as an overall assessment of his risk. And so your request, counsel, is to have the bond lowered so that it's a bond that his family can post.
I mean, I would ask for the court to consider a personal recognizance bond, but at least for it lowered in something in the neighborhood that the family may be able to post so he can be out of custody while this case proceeds. They were able to verify 2 separate release addresses and are recommending release with conditions.
Okay, what is the address that you would be released to?
So either 6820 Richard Road, which is where he was living with his grandmother prior to and at the time of this incident, or the 1218 North High Street in Lansing.
So which one is it gonna be?
I believe Mr. Jones, and I think that's partly because of the court's expressed concern the last time we were here of releasing him to the address where he was residing at the time of this incident as alleged to occur. He's willing to reside at the other address.
Whose address is the High Street address?
Older sister of his girlfriend, I believe. Is that correct, Mr. Jones?
Older sister's
Yeah.
girlfriend?
His girlfriend's
Oh,
older sister.
Friends on his sister, yes, ma'am.
I'm sorry?
His girlfriend's older sister,
And the other address was,
his grandmother's.
that's the 6820 Richards?
Yes.
Okay. He's on juvenile probation.
Correct.
Bond is set at 10,000 personal recognizance with GPS tether and victim notification if possible. You're not to be within 2,000 feet of any of the alleged victims, including a Kamari McCray stump. I believe that at the time of the arraignment, there was a list of no contacts. Let's see here. Not to have contact with Kamari McCray Stump, Mercedes Cruz, Amani Henry, or Rachel Mackley. You're not to be within 2,000 feet of wherever they are. You cannot have contact with them directly or indirectly. Do you understand that?
Yes, ma'am.
Do you understand what indirect contact means?
Having somebody else contact them?
That's correct. So no communication of any kind. You can't have any family members, friends, associates, reach out and ask any questions. There's no communication at all. That'll get you in huge trouble. Do you understand that?
Yes, ma'am.
Okay. You're going to reside at the address of 6820. And are you employed?
No, ma'am, not yet.
I'm going to institute a curfew of 7 p.m. You need to be in the address of 6820 at 7 p.m. unless you are employed. Once you gain employment, you need to provide that information to pretrial services so your bond can be addressed, okay?
Okay.
Also, while out on bond, you're not to purchase or possess drugs, alcohol, unless you have a valid prescription. You're not to engage in any assaultive or any threatening activity. You're not to possess a firearm or any other dangerous weapon. You're not to have marijuana, and you need to report to pretrial services within 48 hours of your release. And of course, you need to appear for all of your court dates. You have a court date on this?
May 3rd. At 9:30.
Do you have any questions about your bond, sir?
No, ma'am.
Any additional matters for the record?
Nothing from the people.
Nothing from the French, Your Honor. Thank you.
You're all set. Where did Mr. Noakes go? Oh, he's right here. Mr. Noakes, where did your client go? Okay, back on the record in the matter of the people of the state of Michigan versus Alexis Brown. I do have her criminal history, which there was no other prior criminal history. So it would appear height is appropriate. I'll grant sentencing under HYTA status. It'll be 6 months non-reporting. While on probation, you're not to engage in any assaultive or threatening behavior. You're not to use, purchase, or possess a firearm, ammunition, or weapon of any kind. You're not to possess alcohol, drugs, or marijuana without a valid prescription. I am not going to order you to do random PVT at this time. Do you understand that?
Yes.
But understanding that that's still a condition, so if some other incident that you're involved in brings you into interaction with the police and you had alcohol in your system or in your possession, that could put you in jeopardy. You understand that? And I don't think that's something that you want. And then you'll maintain your employment while on probation. Do you have any questions about your probation at this time? Let's see. You have the right to request early discharge from probation after you complete 90 days, so long as there's no violation of the probation status. Your probation officer can make that request on your behalf. If he does, he'll notify the prosecutor. And if it's up for a hearing, you can hire an attorney. You don't have the right to have court-appointed counsel for any such hearing. If you'd like to make your own request, you go on the court website, get the MC 512 form. You will complete that form requesting early discharge from probation. You'll serve a copy of that on the prosecutor's office and a copy to the probation officer. Do you have any questions about your right to early discharge? Any additional matters for the record?
Nothing from the people.
No chance, thank you.
You're all set, ma'am. Thank you. I think this just goes. Okay, Mr. Goodrich, you have Demarion Adams. On the record, in the matter of the people of the state of Michigan versus Demarion LaShawn Adams and file number 23-03304 FY, Council of Terrence.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Attorney Luke Goodrich from the Public Defender's Office, here to represent Mr. Adams, who is standing to my right.
Okay, today's the date set for preliminary examination. Are we proceeding today?
Your Honor, it's my understanding that, all the prosecution's witnesses are here, and as a result, Mr. Adams would like to waive his preliminary exam this time.
The people would also unconditionally waive the right to a preliminary exam as the case is ongoing or charged.
Okay, and Mr. Adams, that's correct. You want to waive your examination? You understand that you have the right to this preliminary examination, and you have the right to require the prosecution put forth evidence that would establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. Anybody threatening you to get you to waive that exam?
No.
Okay, and you're waiving it freely and voluntarily? And it's unconditional, meaning you understand that it's not being waived due to any promises or conditions not stated here on the record. And once this matter gets brought over to the circuit court, you can't change your mind. Your bind over date's going to be May 1st. That's the date the circuit court gets the file from the district court. You do not need to appear in court on that date, okay? Unless your attorney wants you to be rearranged for some reason at the circuit court level. Your next court date is going to be a pre-trial at circuit court. Mr. Goodrich will be made aware of that date. Do you have any questions for the court? A bond was set at 3,500, 10%. That will continue. Any additional matters for the record?
Nothing from the people.
No, Your Honor. Thank you.
Thank you. You're all set.
Thank you.
Are we running Eddington? Okay, we can bring Eddington up.
We're still waiting for Mr. Pfeiffer.
Oh, that's Mr. Pfeiffer's case.
You give me, yeah.
Ms. Robinson.
I'm ready on Mr. Shelton. Just,
Yeah, that's just gonna be an adjournment.
right, yeah, I think we just need to put it on the record. Would you like me to bring him in?
Yes, please. Bibles wanna run Greer?
I'm not sure that's how that works. That should be how it works.
Move your hood, please. On the record in the matter of the people of the state of Michigan versus Markel Shelton, file number 24-00906. Council appearance.
Prosecutor Casey Trusty on behalf of the people. Robinson, assistant public defender for Mr. Shelton.
Okay, Mr. Shelton, today's the date and time that's scheduled for a preliminary examination on one count of weapons carrying concealed. And my understanding is that the necessary officer is tied up on another matter and unable to appear today.
That's correct, Your Honor.
And so you're making a request for a good cause adjournment.
Yes, my apologies. Yes, we need a requesting good cause adjournment.
Okay, and are you, on behalf of your client, objecting?
Yes, we are, Judge. We would object to the good cause.
And the objection is noted, it's overruled because it's outside of the prosecution and the officers' control that they got tied up in another investigation today. And so the court's gonna find good cause to adjourn this, dismissing it would not be in the interest of justice because they're just gonna reissue it against you and you'll have to be rearranged. And that takes time away from you, it takes time away from the court and time away from the public defender's office. So we're gonna go ahead and reset this for another date and time. June 21st at 9. June 21st at 9 a.m.
At 9, you said?
Yes. Get you a copy of the notice to appear. Do you have any questions today? Any additional matters for the record?
Nothing for the I'm from the defense. Thank you, Judge.
Thank you, you're all set. Do we know where Mr. Piper is?
Mr. Piper, I know he had another hearing in front of Judge Dragonchuck, and so he was trying to get here as quickly as he could. That other hearing is set for 2 p.m. So yeah, as far as I know, he's trying to get here as quickly as he can, but I don't know where exactly the process he is.
Okay, and then Ferguson, Greer.
He's been in and out. I do know the people already proceed on here.
Ferguson. That one started, it's 2:30.
Morning, Judge. Good afternoon, excuse me.
Good afternoon. On the record in the matter of the people of the state of Michigan versus Frederick Lamont Greer, file number 24-00695, FY, council appearance.
Prosecutor Paige Petrowski on behalf of the people.
And good morning, or good afternoon, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Frederick Greer, who's standing to my right this morning.
Thank you. How are you, Mr. Greer? Okay, today was the date set for a preliminary examination. My understanding is that we're ready to proceed. Is that accurate?
The people already proceed.
That's accurate from the bench. The only thing I would ask, and I do not believe it's an issue, because I think there's only one witness, but if there are other witnesses pertaining to this case, I have to change.
Frustration is granted. Oh, yeah.
I have 2 witnesses subpoenaed. One of them is an officer, but I anticipate that I will only need to call from the victim.
Okay, you can call your witness.
Oh, and Ms. Nash, I will be needing 1 exhibit.
Okay.
I will go get Mr. Everett.
You can have a seat, sir. I need you to stand and face me and raise your right hand first. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes. I
Okay, you
do.
can have a seat, sir.
Thank you.
Yeah, it's very small. It's a tight quarter, so I understand if you need to move the seat up. We just need to make sure that that microphone that's there is close to you, because she has to be able to take down everything that's being stated today. So all of your responses must be verbal and loud and clear. There are fans going because it's very warm in here, so you might need to talk warmer than your loudest talking voice, okay?
Okay.
If
no
there's an
problem.
objection from either side, you would stop speaking. I'll make a ruling on the objection, and then I'll tell you if you can give us the answer or not, okay?
All right.
State your first and last name and spell them both.
My name is Stanley Embry, Stanley Embry.
You can proceed, counsel.
Thank you, Your Honor. Good afternoon, Mr. Embry. How are you doing today?
I'm blessed.
Were you living at 3236 West Holmes Road on January 14th, 2024?
Yes, ma'am.
And is that located in the city of Lansing,
Yes,
Ingham County,
yes, ma'am.
state of Michigan?
Yes,
And what kind of property is that address?
it's a duplex.
So I want to go back to that day, January 14th. What were you doing that evening?
Actually, I was with my nephew and we was watching the football game, and then I had company later on that evening.
And about how many people, when everyone was over, about how many people was that?
It was 4 of us.
Four? And so while you're having company over, did something out of the ordinary happen?
Yes, late that night, my door was kicked in.
Okay. So, before that, your door was kicked in, did you hear anything or see anything out of the ordinary?
I heard my phone go off because of the cameras, but I didn't pay no attention
Okay.
to it. But then I heard knocking, and then my door came flying open.
Okay. So when you said your door came flying open, where were you in relation to that door?
In the basement,
Okay. And how close is the basement to where the door was?
straight down. As soon as the door opened, it's right there.
Okay, so you're able to see the door from where you were.
Yeah, I heard the door fly open. I was by the far wall.
Okay. And so when you heard or you saw the door flying open, what happened next?
This person, I don't want to be disrespectful in the courtroom, came running in my house, went up the steps and then came down. And then got overly excited when he trying to tell me he wants me. And I'm looking at him saying that his mind wasn't right. So I stood there, called the police, and I didn't go no farther or try to attack him. I could have made it a lot worse, but I didn't. And then he wrestled with the woman that was down there, his baby mama, and he sat up there and got into it with my nephew.
Okay, so I'm gonna kind of go back and we're gonna walk through everything you just told me there. So when you said that he ran inside, was that did his entire body enter your home?
All the way to my basement. I mean, if he would have knocked, it would have been one thing, but he kicked my door in.
Okay. And was the door damaged at all?
Yes, I had to repair it.
Okay. How was the door damaged? Like in what way?
The frame was broke. I had to redo the frame.
And did the person who busted or broke into your home, did he have permission to be there?
No,
And did you recognize the person who had broken in?
yes, I did.
How'd you recognize him?
I mean, he came in, and I've seen him before. This ain't the first go around from him running up on me.
Okay. And what do you mean by that, running up on you?
He had assaulted me on January 3rd of the following year. At Dollar General.
Okay.
Of 2023?
Yes,
And so you said January 3rd of 2023?
yes.
Okay. And so, and when that happened, when that had occurred, did he approach you when that in it?
Yes, I was in the store, grabbing a few things, personal things for myself and whatnot. And he approached
Objection
me
is
from,
irrelevant to what happened back in January.
How is it relevant?
For a number of reasons. One, I think that it speaks to his ability to recognize Mr. Greer in this case, which is where this was leading, that he had previous encounters with him. He was very well acquainted with him, and that's the basis of his identification. But then also, as I informed Mr. Feigelson previously, if it comes out in testimony that this is a sustained, there's been sustained unwanted contacts, then people would potentially be arguing for the addition of stalking in this case.
Addition of what?
Stalking.
Okay. Objection is overruled.
So yeah, so you were at the store, and so he approached you. And just very briefly, can you just describe what happened in that incident?
well, as I was approaching my vehicle to get in, he stepped up behind me saying, yeah, and he called me a few choice names and said, what up now, and all this. And so instead of me putting my bags in the car, I sat him on the ground and told him personally, hey, I don't have no beef with you. You need to talk to your baby mama, trying to squash it right there as a man and stuff. And I sat there and tried to talk to him. He attempted to listen. As soon as I turned my head, he stole on me. Yeah.
I just gotta stop you there. He approached you and said, what up now?
Yeah,
Okay, so you are familiar with him prior to that incident.
yes.
How are you familiar with him?
He think that me and his baby mama been friends for a long time. And he sat up there and always came at me about it. He pulled up on me with my grandson
So
in the car.
you know him from, one of your friends has a child with him?
Yes,
Okay, you can continue.
And so during that that encounter, I guess, and I apologize, did you say that he stole from you?
no, he sucker punched me.
Oh, okay, I missed
Rephrased that, yeah,
Sorry.
yeah,
Okay, so
sucker
you
punch.
sucker punch. Okay,
Yeah, he didn't steal nothing.
He
from
stole
me.
on
He
him.
loved
Oh,
me. Yeah,
street
he
language.
stole on me.
I'm
Yeah.
sorry. Really.
Yeah, it's a whole different slang talk.
Apologize.
Yeah,
Okay. So, all right. So, between that incident and then the January 14th incident, did you have any other contacts with Mr. Greer?
besides him calling and I didn't know it was him, like the first court date that we supposed to have, it was a detective. They claimed it was a detective before the 22nd, saying that my court was postponed. Then I didn't look at the calendar, or I would have known that that date that they said was on a Saturday. And then everybody's calling me about a post that was put up from this person about I beat the case like Rocky. I didn't look it up or anything, but I had got plenty of phone calls about it, like I was talking.
And then from both those prior incidents and then also the January 14th incident, were you able to see Mr. Greer's face at any point during that?
No, I haven't seen it since he did what he did on the 14th.
Yes. Let me rephrase. When on the 14th, when you saw him, were you able to see what he looked like?
Yes,
Okay. And would you recognize him if you saw him again?
yes,
Is he present in the courtroom today?
yes.
Can you describe where he's located in an article of his clothing?
Black and red, right there with his head down.
Let the record reflect that Mr. Embry has identified the defendant.
No
objection, Your Honor.
Identification is noted.
So circling back kind of to the 14th, after you observed the defendant force open the door, You said that he approached one of the women at your home.
Yes, I mean, she was being defensive, trying to make sure that he didn't run up on me or whatever, trying to be helpful. But, you know, I stood there waiting, stood my ground. I didn't approach him with what I could have for kicking my door in.
Mhm.
I called the police and was letting them handle it.
And so, I guess, did you call the police while Mr. Greer was in your home?
Standing there overly excited and hollering, he wants me.
He wants you?
He wants me.
And what were you thinking when you were hearing him say that to you?
Dropping him, to be honest.
Okay.
Dropping him?
Yeah,
What does that mean?
knocking him off, do whatever it takes, that because he disrespected my house and I be having my grandkids and everything up in there. And I would have did whatever it took, but the good Lord didn't let me go that route. You know, I don't have no beef with this guy. He just keeps coming at me.
And so just for pure clarity's sake, even though you were thinking about that, you never
I
initiated.
didn't touch him as far as doing anything to him.
So then, once you call the police, what does defendant do?
Well, after he left the first time, not,
So I'm gonna stop you right there. So when in this does he leave?
okay, my nephew wrestled with him, choked him out, then asked him to get up and leave. He grabbed my nephew's phone, ran out with it and everything, and we thought he was gone, so I secured my door from being kicked in. And after the police that came, they looked and seen everything and, you know, took a police report, took video off my phone and got that on tape. We thought it was done. The police left. And then shortly after, my door was kicked in again a second time.
Okay. So when you said that you secured the door, how did you do that?
I had put a chair and, you know, called myself putting like try to wedge a little screwdriver to, you know, because normally I don't have this type of problem at my house.
Right.
And it was kicked in again.
So that second time, where were you located when
We
it
were
happened again?
still in the basement. We was talking about what was going on and everything. And I was still, you know, mesmerized by what was going down. For him to come with a weapon this time, pointing it at my nephew and the women that was downstairs.
Yeah, so we'll get in that in just a second.
Yeah.
So you were in the basement, you were able to observe when he kicked in or forced in the door a second time.
Second time.
And then what did he do after he forced the door open?
He come running down the stairs with the weapon pointed. And then he was pointed at my nephew. Then he moved his arm around like throughout the basement. My nephew got behind the water heater trying to duck and dodge. I approached him. I mean, you know, this is my home. I'm not gonna have nobody threatened in my home like that. It is what it is there. And I went up to him.
And so you could see the weapon in his hand. Can you describe it?
It looked like a black handle, 9, some type, you know, from what I've seen.
The handgun though.
Yeah, handgun.
And when Mr. Greer was pointing the gun at your nephew, could you see like where he was pointing it on your nephew's body? Like
The upper part until he went down. And then when I started approaching him, he pointed at me straight to my face.
and where was he looking when he was pointing the weapon at your face?
He was looking at me walking up on him.
And could you see his hands at that time?
Yes, he had the gun, and when I got close enough, he took the gun and struck me in the head with it.
And so when he hit you on the head, what side or where on your head did he hit you?
He hit me on the left hand side of the head.
No, he said left and pointed to his right side.
Where did he hit you?
On the left side.
Which
This
side?
is my right, this is my left. Right here, this is the left. Yeah, I said the left side.
his hand's on the right side. If you put it where his nose is, he's pointing on this side of his face, which is the right hand side of
He
his
said
head.
he hit me on
On
the
the
left side, and
left-hand
he's touching
side
his left
of
side
my
of his
head.
head.
But he's touching the right side.
That's his
Oh.
left side of his head. He's,
Okay.
he's, this is his left hand.
Well,
This is right. on
this is
facing-
right.
Okay.
Thank you.
All right. So then, you said that he hit you on the left side of your head.
Yes,
What was going through your mind when that happened?
it hurt him bad. He ran up the steps and was able to escape. I didn't chase him. I mean, I'm an older person. I'm not gonna chase no guy younger and be tired so they could beat me up or whatever. So he was allowed to escape from my house for a second time.
And I know you were saying that you walked towards him and you approached him. At any point when you were approaching him, did you were you talking with him?
I may have said something, I don't recall saying anything. I was approaching him to see what he was really gonna do. We was gonna end this right there.
And then at that point, that was when he hit you.
Struck me, yes.
Oh, and apologize, forgot to ask one question. When he was pointing the gun at you, prior to hitting you, could you see where his fingers were on the gun?
Oh, well, he swung the trigger a couple of times.
So he had the gun pointed
Yeah.
at you and pulled the trigger
Yeah, he did.
multiple times?
He did.
And what was, when you witnessed him do that, what were you thinking?
I could have been dead. I could have been shot or anything. I mean, by the grace of God, it wasn't, I don't know if there was anything in it or loaded or anything, but I heard the click.
Did you
Yeah.
did you see his fingers move at all?
Yes. And then he raised it over his head and hit me.
And so then after he hit you with the weapon, at that point, that's when he leaves your home?
Yeah, he ended up taking off.
And what did you do next?
Well, before he took off, I pushed at him because he hit me in the head and I pushed him. And he turned around and got out the door.
And when you pushed him, that was after. he hit
After
you.
he hit me, yes.
Okay. So once he runs out the door, what happens next?
Well, shortly after, police came again. They called the ambulance to make sure I didn't need no stitches because I was bleeding from the head.
So actually, I would want to talk to you about that a bit too. When police arrived, did they take any photos of you?
Yeah, they took pictures.
And I'm gonna, Ms. Nash, did you have that, the exhibit sticker?
Yeah.
May I approach you?
Yes.
I'm going to show you what's been marked as people's proposed exhibit number 1. Do you recognize what's in that photo?
Yeah, the blood and piece of skin spilled from my head from him hitting me with the weapon.
And is that an accurate representation of what your head looked like when you were speaking with police?
Yes, well, they cleaned it up a little bit. It was a little more.
People move to admit people's exhibit number 1.
Any objections?
No objection.
People's one is admitted.
Thank you. So, so you're saying that that depicts the wound that you suffered from being hit in the head?
Yes.
And how did that like physically feel on your body when at that time?
I was too angry to even realize what I was doing. I had other thoughts in my mind, to be honest.
Commissioner published to report.
Yes.
So then after defendant left your home the second time and after police are gone and everything, did defendant ever return to your home again?
Yeah, she came back a third time with a hammer, busted my headlights, my windshield, and both my driver's side windows, and left the hammer in the car.
And about how long had it been from when he left your home the first time to when he returned the third time? Or excuse me, when he left the second time and returned?
Within, the police was there for about a half hour or so. And as soon as they left, I'm pretty sure he was just stalking and waiting until they was gone and came back and did it again. And I busted through the door when I heard that he was back out there. Now, I was coming out so I could deal with this guy tearing up my vehicle, which I never heard no guy tearing up no other man's vehicle. And he takes off running after he tried to get in the car because the hammer fell in the car.
And so your car, when this was happening, your car was located outside. Is
Yeah,
that correct? Okay. And then when you heard things happening, that's when you went outside?
yes.
And then how did you know that the person vandalizing your vehicle, how did you know that that was?
Heard the noise.
Oh, you
I heard the noise, yeah, because I was looking at my camera and it went off after he broke my headlights and then started in on my windshield, and I started headed that way. He had been able to hit both driver's side windows and lost the hammer inside the car.
And you were able to see, were you able to see the person, his face when this was happening?
I've seen him, yes.
And do you remember what clothes he was wearing?
I don't recall what he had on, but yeah.
And then just briefly, how has this whole incident impacted your life?
Well, it got family members upset. It got me highly upset. People is nervous of coming over, thinking that they have to bring weapons and stuff, which never had to be at my house like that. You know, I mean, I never had to go through no type of encounter with no one. I show a lot of love out here in the streets. I feed the elderly. I take look out for homeless, give them money and stuff. For me to go through this, knowing that I show love to everybody, I feel that I shouldn't have had to go through this, and I've been going through a lot of anger with this. It done cost me time, money, and everything, because my car was broke down for about 2 or 3 months of even helping the people. I had to borrow other people's car to feed people that they ain't got nothing to eat or anything.
And with the damage to your car, so you were unable to drive it?
Yes, I couldn't drive it for a while. It cost me over $6,000 to fix it.
That was gonna be my next question. So, and then also, do you know about how much it costs to repair your home's doorway?
It was a few $100 to fix that, yeah.
No further questions.
Cross-examination.
Thank you. Good afternoon, Mr. Humphrey.
Yes, sir.
So I want to turn your attention back. You said that you ran into Mr. Greer at a store in January of 23 or 24?
Pardon me? The year of 23.
So a year before this incident?
Yes, the year before.
And between those two times, have you had any contact with Mr. Greer since that? Between January of 23 and January of 24, the alleged incident, have you had any contact with him in between that period?
Phone calling and stuff, but he never approached me since then. I didn't see him, no.
So now you said on the 14th of January of this year, you were at your house watching the Lions game, I presume?
We was watching the football game at night, me and my nephew.
The Lions.
We had, yeah, we had company later on.
Now, were you guys drinking? Were you under the influence of anything that would impact your ability to remember what happened that night?
No, I wasn't drinking. I was actually playing music and talking with my nephew.
Okay. What about your nephew? Do you know if he was intoxicated?
Nobody was intoxicated.
Okay. Well, because law enforcement showed up, is that correct, that night?
Yes.
And isn't it true that some of the folks there refused to cooperate with law enforcement?
They didn't want to get involved for personal reasons, that it was jeopardizing, may jeopardize his job, and And then his baby mama didn't want to get involved just because she had respect for him and everything too.
Okay, so
You know,
you
and I
said,
wasn't forcing the issue.
so you said baby's mom was at Mr. Greer's mother of his child was at his house, is that correct?
Yes.
And do you know if he knew she was present at the house that night?
She was there.
That's not what my question is. Do you know if he knew that she was present? Was there any communication between the two of them to indicate?
I have no clue if she talked to him. I doubt it.
Okay. So we have no way of knowing whether anybody was, you were there, or whoever would have been there to arrive, is that correct? Is that fair to say? If he hadn't been there in a year and talked to you or his baby's mom in a while, you have no way of knowing who. You show up, all of a sudden out of the blue, he shows up, is what you're saying.
Of course, I believe it's because her vehicle was parked next to mine.
How often do you guys live near each other? You have any idea where you live?
Yeah, I know where she lived.
No, not where, do you know where Mr. Greer?
No, I have no clue of where he lived.
Okay, so you have no idea if you would have even been able to drive by in his proximity.
He gets in different vehicles and ride by or jumps in front of me, and I know it's him, but
Okay, so let's turn back to the event. So you said that he comes over the first time, is that correct? You said you were mad and wanted to drop him, is that correct?
I wasn't mad until he kicked in my door. Anybody would be mad after they kick in your door.
I was talking about the night at the Dollar General back in January.
I wasn't mad about nothing. I was caught off guard then.
But you said you wanted to drop him. Is that
No,
correct?
I said that in my basement.
Okay. And why'd you want to drop him at that point?
He kicked my door and my grandkids could have been in that house or anything.
Okay. And you mentioned that, did he have a gun with him the first time?
He didn't show one. No, I didn't see one.
They said you thought he had a gun with him the first time, is that correct?
I didn't say I thought nothing. I didn't see one.
No, the second time he had.
He had one. It's on tape. It's on camera. They got pictures of it.
And you said he made a clicking sound. You know if that bullets in the gun?
No, I don't.
Did he say anything to you indicating he was intending to fire or anything?
No, he didn't. He didn't say nothing.
Guys. What time do we go to this one?
Redirect.
So you were being examined by Mr. Feigelson. You had said that there had been some phone calls in between the January 2023 incident and the the January 2024 incident. That's correct.
Yes,
Okay. And so in those phone calls, those were defendant calling you?
I couldn't prove it, but by someone calling, pretending that there was a detective and saying that the court date was postponed, it was nobody else that would do nothing like that. So I figured that he had something.
Jackson, I don't think that was the question. She asked between the two Januaries, Your Honor. I think he answered something that was not part of
Your
it.
voice is a little bit low for all the fans. Can you say it a little louder?
I think she asked the question, but I don't think he answered the question. She's given information that to me the question. Her question was a new arrangement between January and January. He's asking, he's answering something that happened after the timeline in question.
January to January?
Yes.
Yeah, I was just about to re-ask my question more clearly. So
Okay. The objections is saying, you can rephrase your question.
So so aside from that phone call that you had previously spoke about, between January 2023 and then the January 14th of 2024, apart from the phone call you just mentioned, were there any other phone calls made to you?
I couldn't prove that. I was getting calls and hang up. I couldn't prove those phone calls.
Was anyone ever speaking during those calls?
I didn't hear nothing. They listened and then hang up.
And then in reference to your friend, the mother of Mr. Greer's child, do you know how long she's had that vehicle that was that she had on the 14th?
Over a year or so, yeah.
Okay, so all right. And then and you said that was parked out front next to your vehicle?
Yes.
Okay. Were there other vehicles parked there, or was it just the
I
two?
had a Buick behind my Lexus, and that was untouched.
Okay.
Along with hers, but, you know, I wasn't thinking about none of that. I mean, he went to the main vehicle that I try to help and feed people with, and took my grandkids around.
No further questions.
Can this witness be excused?
Yes, he may.
Thank you. You may be excused, sir. Any additional witnesses today?
No, Your Honor.
Is the defense calling witnesses?
None for person privilege, Mayor.
Argument.
Thank you, Your Honor. We heard testimony from Mr. Stanley Embry today. Mr. Embry stated that he previously had several contacts with defendant, and that defendant had some issues with him due to issues of a mutual friend. Mr. Embry testified that on January 14th of 2024 at 3236 West Holmes in Lansing, Ingham, Michigan, that he was having a small get together with some company over, and then at that point while they were in the basement, he observed the defendant in this case break down his door. He used the phrase kicked in, but he did not see kicking. So, but regardless, some sort of force was used to force open and break open his door. And that defendant did not have permission to be in his home. After breaking open the door, defendant entered the home. He, it sounds like, physically assaulted some of the guests there, but also in the process of breaking into the home, committed a malicious destruction of a building. He broke the apertures of the home by breaking the door frame and causing approximately, I believe he said, I don't know exactly, a few $100s worth of damage. And also when Mr. Greer was in the home, there was also other people who were lawfully present within the dwelling. The second charge of the second home invasion first degree charge occurred when, as Mr. Embry testified to, defendant returned to the home a second time, broke in a door that he said had been, he had basically barricaded because he had no other way to secure the door. That door was broken a second time. Defendant entered the home again, his full body, without permission again. And at that point, he committed several state offenses. And he also was armed with a dangerous weapon that he used to point at both Mr. Embry's nephew and also at Mr. Embry. And then those people were also lawfully present there at that time. For the charges, for the charge of felonious assault, Mr. Embry testified to the fact that he was hit by the weapon that Mr. Greer brought into the home, by the black handgun. And we have the exhibit that shows the injury that he sustained from that incident. Also, while Mr. Greer was within the home, he also, in the course of pointing the weapon at Mr. Embry, proceeded to hold the gun very close to his head, point it at him directly, and pull the trigger multiple times. That is not conduct of somebody who is simply trying to just assault for the purposes of injury. That is the conduct of somebody who intends to commit murder. That by pointing the gun at someone's head, pulling the trigger, I mean, Mr. Embry heard the noise and thought that he was going to die potentially that night. And so for those, based upon that evidence, the people would also be adding an additional charge of assault with intent to murder in this case.
Request to add count. You're requesting to add a count 6 or to amend the count?
Add a count 6.
Add a count 6 of what?
Assault with intent to murder. And I have a pack code if you'd like that right now. Or
Yes, please.
Yep, it's MCL 75083. Thank you. And then also for the charges of the felony firearm, when he broke into the home the second time, so the second charge of home invasion first degree, Mr. Embry witnessed him holding a weapon and then brandishing it while he was in the home. And then additionally, when he hit Mr. Embry on the head with the gun, he was using the dangerous weapon of the gun to hit him in the head. And as additionally, when he committed committed the charge of the assault with intent to murder, he did so by pointing a gun at Mr. Embry's face. And so people would also be requesting an additional charge of felony firearm for the charge of the assault with intent to murder. I have the backup for that. Be ready.
Yes, please.
So it's MCL 750.227B-A. And then at that point, although it is a misdemeanor and Mr. Embry was not required to, or not required, but the people were not required to provide any evidence of that instance. Mr. Embry provided pretty substantial testimony about the degree of damage done to his property that by a defendant while he was at his house at those 3 separate times. Additionally, due to the fact that this is taking place in the course of, it's the same sequence of conduct basically by Mr. Greer in this case. The people feel that it would be appropriate to join together both Mr. Greer's misdemeanor case, case number joining together his misdemeanor file for the aggravated assault committed by Mr. Greer on Mr. Embry, court number 23-03610 with this case, as they were joined by the common conduct of the stalking taken place by Mr. Greer, or undertaken by Mr. Greer. Additionally, we'd be adding another misdemeanor charge of stalking in this case. There was Mr. Embry detailed several instances of unconsented to contact by Mr. Greer that he did not initiate, and that those instances of conduct or contact in both in January 2023, the phone calls that it was his honest belief that were from defendant, as well as the 3 separate times that defendant chose to return to Mr. Greer's home, and then return again to destroy parts of his vehicle. Those are non-consented contacts that would cause a reasonable individual to suffer emotional distress. They clearly caused Mr. Embry to suffer emotional distress. He was very, very angry and felt threatened and harassed. And then that the contacts themselves would cause the individual to feel terrorized, frightened, intimidated, threatened, harassed, or molested, and that those contacts caused him himself to feel that way. So the people would also be requesting an additional count of stalking.
You said that. Are you requesting 2 counts of stalking or?
Just the 1 count of
So I'm
stalking.
up to added count 8. Is that just making sure we're on the same page of stalking? You've added an additional count 6 of assault with intent to murder. You are requesting an additional count of felony firearm and then an additional count of stalking.
Yes, but I believe based off of the number of counts that were already there, the assault with intent to murder would be count 7.
You're correct. 7, 8, and 9.
7, 8, and 9. Yes, that's correct.
Okay. The other question I have is the testimony that this witness provided was that there was over $6,000 in damage, but count 6 says 200 or more, but less than 1,000.
Yes, I believe that charged. Yes, so we would, I think we didn't have the exact numbers at the time that we charged that. And so based off of the testimony provided by Mr. Embry, we would be amending count 6 to the next year charge, which I believe is $1,000 to $20,000. And I also have a packet for that.
Yes.
That would be 750.337 A1B1.
What's the penalty on it?
The penalty on that is 5 years and or $10,000 or 3 times the amount of destruction or injury, whichever is greater.
So it's a felony.
Yes, that's correct.
Okay. Any additional argument?
No, Your Honor.
Mr. Feigelson.
Yeah, Your Honor, a couple of things I'll point out. This is a low standard of proof. I'll start with the added count 6, the assault with intent to murder. I don't think there's enough testimony laid out today to establish this, even in a probable cause. There was nothing indicated from Mr. Embry of what my client's statements were. He doesn't know if there were bullets in the gun. He doesn't know what his intentions were. I don't think there's enough evidence to suggest that that's a proper charge, Your Honor. And of course, that would indicate that the third felony crime would also go away. With regards to the
Can you
stalking.
speak up just a little bit higher because we have 3 fans going.
Yes, Your Honor. With regards to the stalking charge, I know it's a misdemeanor, but there's no evidence to suggest anything to indicate this was stalking behavior. The testimony was there was a contact in January of 23, and then a contact in January of 24, a whole year later.
Well, that's not what he said. He said that there was phone calls.
If he has no proof of who made those calls,
He didn't say that. He said that there was some phone calls in between there.
if he has no idea who they came from.
He said some of those phone calls were hangups. But he didn't say that he didn't get any. He said he had some phone calls. You asked him specifically had he had any communication with the guy in between 23 and 23. You misunderstand the question, 23 and 24. Misunderstood the question. My recollection is that when she rephrased or re-asked the question, he stated, yeah, he had just some phone calls.
I agree with that, but what I'm saying is,
You didn't get an opportunity to recross him on that to clarify that he didn't know who was calling.
he answered that on my cross earlier, then he didn't get a call from my client between January and January.
That was not my understanding of his testimony. My understanding, because you objected, that he didn't answer her question, which is that he didn't get a call from January to January. He said he did, just some phone calls. And then he started talking about.
That's not what I was getting at. On my original cross, I asked him if he had any contact with my client in between January and January. He said no.
Correct. He's also
So that's what I'm basing my argument.
Correct, but he also said he had some phone calls in between that time.
Yeah, but he has no idea who those calls came from.
But, okay, so he assumes that they're from.
Right, but there's no proof of that. To say that's a stalking charge, you can't prove that. You can't prove it was him.
Facts can be proven by circumstantial evidence.
We have no
correct?
evidence it was his. How do we know it
Well,
was a telemarketer?
if you consider the totality of a telemarketer hanging out when you call, that's not what their purpose is, right? They usually want to
know.
talk to you.
I get telemarketers every day. They hang up on me. So
My telemarketers definitely don't hang up on me unless I answer the phone. Sometimes I say, hi, this is Taco Bell, and then they might hang up. But if I answer, it's usually the telemarketer is trying to get something from me. So why would they just hang up after you say hello?
point is, I don't think there's enough evidence to support stalking.
To support stalking? Well, I don't have to address that because they can make a motion to amend a misdemeanor without addressing probable cause.
And the other question I have is she's asking that the misdemeanor be tagged along with this. I don't know if that's something that's able to be done. I'll leave that to the court, but.
They want to add the file 23-610, which I guess is charges of stalking.
That is charged as an aggravated assault.
An aggravated assault against this victim.
Yes, against this victim. It would be the prior incident when he, the Dollar General incident.
Okay, the date was January 23, the date he was talking about.
Yes.
Okay, and to link that, that's why you're asking to add this charge of stalking.
That's correct, Your Honor.
Any further argument from you, Mr. Johnson?
None, Your Honor.
Okay, today was the date that was scheduled for preliminary examination. The burden is upon the prosecutor to establish probable cause. I'm talking to you, Mr. Greer, because your attorney knows all this information, okay? It's a low burden. It's more than mere suspicion that a crime was committed. There's no requirement for them to put on evidence beyond a reasonable doubt here. And the court will be the sole determiner of the credibility of the witnesses. We had one witness today, and it was by an alleged victim, Stanley Embry. He testified that on the date of January 14, 2024, at the address of 3236 West Home Street, that's in the city of Lansing, Ingham County, state of Michigan, making venue in this court appropriate, that he was home watching a game with his nephew. He had some people come over late in the night. He heard the door knock, and then his door was kicked in. He indicated that he was, I believe, in the basement when this happened. He said that prior to the door being kicked in, he heard the phone go off because he has camera alerts, but he ignored it. And then he heard a knocking and the door came flying open. He said this person came running in to his house and got overly excited stating, "I want you." The victim testified that he called the police. He later testified that the alleged suspect was seen wrestling with a woman in his house that the victim identified as the mother of the alleged suspect. And then he got into some level of altercation with the victim's nephew. The victim identified the subject who entered his home without his permission as the person sitting in court as Frederick Lamont Greer. He indicated that there was damage to the front door of his home, that the frame was broken, and that he was familiar with the defendant, and that there had been a prior altercation in which the defendant assaulted him back in January 2023 while at the Dollar General. I'm assuming in Lansing, Ingham County, because I don't have that file before me. A defendant allegedly approached the victim in the July 2023 altercation in a parking lot saying, "What's up now?" The court questioned about the "what's up now" because the court was unclear at that time as to what the relationship was and why anyone would walk up to someone randomly and say, "What's up now?" And that's when the witness gave clarity that one of the victim's friends had a child with Mr. Greer. Mr. Greer talked about a Facebook post referencing this alleged court case in which the defendant allegedly posted he beat the case. Victim testified that during the altercation on January of 2024, and even in the altercation in 2023, that he never touched the defendant, although he wanted to. And he particularly stated that on the incident in January 2024, that he wanted to, I believe he said, down the defendant. He said the defendant on January 2024, before he exited the property after kicking the door in, the second time he grabbed the nephew's phone. I'm sorry, the first time he grabbed the nephew's phone and ran off. The police arrived, they took a report and took video from the scene of the incident. The police left. The victim testified that the door was kicked in a second time. This time he states that the defendant came with a weapon and pointed the weapon at the victim. He said the defendant came into the home a second time, ran downstairs with the weapon, pointing it at him. The weapon was described as a black handle, 9mm possibly, but nonetheless a black handgun. That the victim stated that he heard and visualized the defendant attempting to pull the trigger multiple times. He stated at that time he thought he could have been dead, that nothing ever discharged from the firearm. He was unclear or unknowledgeable as to whether or not the firearm was loaded or whether there was some other issue with the firearm. However, he said after the attempts to pull the trigger, the defendant allegedly struck the victim in the head on the left side of his head. He pointed to the left side of his head for clarification of the record. And we have People's Exhibit 1, which indicates a bruise or injury to the left side of the victim's head. He stated that the police were called and they were in emergency response, checked his head after the assault to ensure that he did not need any stitches. He testified that the defendant came back a third time, this time with a hammer and busting out the headlights and the windshield of his vehicle, causing over $6,000 in damage, and that he was without a vehicle for several months while the vehicle was being repaired. Count 1, as charged in the complaint, is home invasion first degree, as is count 2, which is home invasion first degree. In order to proceed or to sustain that charge at the time of trial, the people would need to prove beyond a reasonable doubt first that the defendant broke into a dwelling. It does not matter whether anything was actually broken. However, some force must have been used. Opening a door, raising a window, and taking off a screen are all examples of enough force to count as a breaking. Entering a dwelling through an already open door or window without using any force does not constitute a breaking. Second, the people would need to prove that the defendant entered the dwelling. It does not matter whether the defendant got his entire body inside. If the defendant put any part of his body into the dwelling after the breaking, that is enough to count as an entry. Third, people would need to prove that when the defendant broke and entered the dwelling, he intended to commit, in this case, an assault with a dangerous weapon as charged in the complaint, and that the defendant entered, when the defendant entered, was present in or leaving the dwelling, he committed, in this case, the alleged incident or charge of assault with intent, assault with a dangerous weapon, that is. Fourth, that the defendant, that when the defendant entered, was present in or leaving the dwelling, either of the following circumstances existed. A, that the defendant was armed with a dangerous weapon and or another person was lawfully present in the dwelling. Again, the court had testimony that the door to Mr. Embry's house was kicked in, and that the person he identified as a defendant came into his entire body, he stated, was inside of the home, and that at the time their defendant became or was overly excited. There was some level of altercation and an assault took place allegedly during that incident. And during the second incident, again, re-kicking the door in after he had barged the door, the victim barging the door back closed. And this time the defendant allegedly appearing with a firearm and assaulting the defendant in the head with by striking him with the firearm in his hand. The court is satisfied that there is sufficient probable cause as to both counts 1 and count 2. And count 3, assault with a dangerous weapon, that being felonious assault. People are asking to add a count. People are asking to add a count of assault with intent to murder. The defense is arguing that there is not sufficient probable cause as to assault with intent to murder because there was no statement made. So I think what you said your argument was, Mr. Pikelson, from the defendant that would indicate that he intended to murder or what he was intending to do, or that the victim didn't appear to have any knowledge as to whether or not the firearm was loaded. To prove it at trial, the people would have to prove, first, the defendant tried to physically injure another person, second, that the defendant committed an assault and had the ability to cause an injury, or at least believed he had the ability, third, that the defendant intended to kill the person he assaulted, and the circumstances did not legally excuse or reduce the crime. And so we had testimony that the second time that the defendant allegedly returned without permission to Mr. Embry's home, that he pointed a firearm at Mr. Embry. Mr. Embry stated that he heard and saw the defendant attempt to pull the trigger multiple times. I think that a reasonable person would conclude if that you point a firearm, which is a dangerous weapon, at someone's head, and you're pulling the trigger multiple times, that you believe that you have the ability to cause an injury, and that is an injury that is likely to lead to death. The court is satisfied that there is sufficient probable cause to bind over the added count of assault with intent to murder. So that will accompany counts 1 and count 2 and count 3. Count 4 is a weapons felony firearm. Count 5 is a felony firearm to accompany the previously bound over charges, and the people are asking to add an additional count of felony firearm that would accompany the assault with intent to murder. Is that correct?
That's correct, Your Honor.
Okay, based on the testimony presented today, the court will add the additional count 8, that is a felony firearm, and count 8 as well as count 4 and count 5 of weapons felony firearm will be bound over to the circuit court. Count 6 is charged as a malicious destruction of personal property. However, based on the testimony It's charged as a misdemeanor, but the testimony provided that the damage allegedly caused to the victim's vehicle was over $6,000. And to prove this at trial, the people would need to then prove first that the defendant did willfully and maliciously destroy or injure the door and car window of the personal property of Stanley Embry, and that the amount of the destruction in this case was more than $1,000 but less than $20,000. The court is satisfied that there's sufficient testimony evidence to support the addition of count 9. I'm sorry, that was actually going to be count 6 amended. Amending count 6 to malicious destruction of property 1,000, more than 1,000 or less than 20,000. So that will be amended and bound over to the circuit court. The people are asking to add a misdemeanor count 9 of stalking based on the testimony evidence that there had been multiple events of unsolicited contact between Mr. Embry and Mr. Greer. Mr. Feigelson objects to that. He does not believe that there is sufficient basis for an added count. I indicated that it's not a misdemeanor. They don't need to address probable cause for that purpose, but taking into consideration the statements made by the witness today, there was at least testimony of one incident having occurred when the defendant approached or allegedly approached the victim in a parking lot at a Dollar General saying, "What's up now?" The testimony is unclear as to whether or not there was communication or contact between this victim and defendant in between that January 2023 and January 2024 event. But the court is confident that there was testimony that there was some other instances where the victim believes that the defendant made contact with him, and the victim even testified that there would be times that he would be driving on the road and the person that he believed to be a defendant would cut him off. He knew it was him, is what he stated. And then the instances occurring here on January 14, 2024, where every time the police allegedly leaves the house, the defendant returns back to the home. Based on that, the court believes that there is a sufficient nexus to join and connect the alleged charge of aggravated assault and file number 23-610. And so for the efficiency of prosecuting these cases and in the interest of judicial economy, that count or that charge will be merged with this file, and it can be prosecuted together, linking that stalking, because the stalking will be added as a count 9. And then once that's linked, the count 10 will be the aggravated assault. And so bind over on all counts will be May 1st. That's the date that the circuit court is going to get the file from the district court. You do not need to appear in circuit court unless Mr. Feigelson is going to make a request for you to appear on the 1st of May to be rearranged. You understand that, Mr. Greer?
Ma'am.
The next court date, unless you're rearranged, is going to be a pre-trial in circuit court. Mr. Feigelson will be made aware of that. You stay in contact with him. Make sure he has any changes to your address or phone number, okay?
Yes, ma'am.
Do you have any questions for the court at this time?
No, ma'am.
The bond is set at 10,000 personal recognizance. There's a no contact order. Any additional matters for the record?
Your Honor, the people would like to address the bond in this case.
Proceed.
Thank you. I believe given that, given the testimony that we heard today, and the fact that there have been a number of new charges added to this case, including incredibly severe and serious charge of assault with intent to murder. And due to the fact the element that the stalking plays in this case, I think that it is a matter of both public safety and safety for the victim in this case for bond to be adjusted to a high cash surety bond. And so if the court chooses not to pursue that, then the people would simply be requesting that a GPS tether be added. I believe that there is an exclusion zone currently, but that there is no GPS tether at the moment. Victim or Mr. Embry expressed considerable concern about the safety of himself and his family members in the community. And so people feel that it would be appropriate to adjust the bond in this case.
Mr. Pyros.
Mr. Ryan asked that the bond amount be continued as it is, because if the court's inclined to put a tether on, I think that would be appropriate, Your Honor. This case is from January. This is a reissue. There's been no allegations that Mr. Ryan had any contact with Mr. Embry here, Your Honor. I know that there's been sometimes when Mr. Embry had about calls he got, but he has no idea who they were from or whether they were from Mr. Greer. To me, that doesn't rise enough of the level here to warrant. I know there's been an addition of charges, but some of those charges probably should have been added based upon what was at least when they decided to charge this. So my argument is that should already be factored into the bond. I just think the bond remain as is. The court's inclined to do GPS tether. The defense is simple.
I don't have the defendant's prior criminal history, which the judge had at the time that she originally arraigned him. Of course, she was originally arraigning him on the charges of home invasion, first degree 2 counts, and assault with a dangerous weapon, felony firearm, and malicious destruction of personal property. There are increased or enhanced charges now, adding the assault with intent to murder, and then allegations of stalking. I don't have, at least at this time, any information that suggests that he has any prior assaultive crimes. Do you have that information?
I'm pulling it up right now. He has a prior felony firearm charge, as well as a prior 2 prior domestic violence charges.
I was aware of the felony firearm because this is being charged as a habitual offender, second offender. Mr. Patterson?
Yeah, just clarification, that felony firearm was from 2011. So that's something.
He's being charged with a second offense notice because of that. So
Well, I understand that, but it's not.
it's still enhancing his sentence to 1 and 1 half time the maximum sentence on the primary offense. That's all. We can't negate that because of the time. And I just wanted to know if he had prior assaultive charges on his criminal history, because we have allegations of assaultive and threatening activity. I think adding a GPS tether, considering the additional charge of assault with intent to murder, and the added count of stalking is appropriate. So the court will have him remanded so that he can get a GPS tether today. He's not to be within 2,000 feet of Stanley Embry's home or any place where Stanley Embry will be. Do you understand the no contact order? Not to be within 2,000 feet of wherever Mr. Embry is. You're not to have contact directly or indirectly with Mr. Embry. And then we'll provide victim notification if possible to Mr. Embry.
So the only question I have is Mr. Embry would like to make a phone call to these two that drove here.
Want to get your car, is what you're saying?
Yeah.
That's fine. You can make a phone call. Any additional matters, I'll go off the record.
No,
Your Honor.
On the record, in the matter of the people. Wait, you said somebody's, it's going to be a German, and who's the other one?
Barksdale, people will be asking for an adjournment, and then Beasley, my understanding it'll be a waiver.
Okay, on the record, in the matter of the people of the state of Michigan versus Kim Beasley, file number 24-00685, council defendants.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Here, Robinson, Assistant Public Defender for Mr. Beasley.
Okay, how are you, Mr. Beasley?
How you doing?
I'm well, thank you. Okay, today was the date and the time that was scheduled for a preliminary examination. One count of officer fleeing, eluding third degree. How do you want to proceed?
Your Honor, this will be a waiver. We will be waiving the right to the preliminary examination unconditionally.
And the people would also unconditionally waive the right to preliminary examination, and that's the case is under first charge.
Okay, Mr. Beasley, you want to waive your exam? You want to
Yes,
waive your
yes, ma'am.
exam?
Yes, ma'am.
Do you understand the purpose of the exam?
Yes, ma'am. You tell me. Yes, ma'am.
So you have the right to require the prosecutor put forth evidence that would support that they have sufficient probable cause that a crime was committed and then probable cause to charge you with the crime.
Yes, ma'am.
You know that waiver is unconditional.
Yes, ma'am.
Anybody threatening you to get you to waive? Any promises being made to you if you waive your exam?
No, ma'am.
You understand that once this case is found over, you can't change your mind. Find your waiver to be freely and voluntarily made with bind over dates May 1st. So that's the date the circuit court gets the file from this court. You do not have to appear in court on that date, okay? Your next court date, unless for some reason Ms. Robinson thinks you need to be rearranged, will be a pre-trial, and she'll be made aware of that date. You stay in contact with her make sure she has any updates to your contact information if you change it between now and then, okay? Bond was set at 3,000 personal recognizance that will continue. Any additional matters for the record?
Nothing from the people.
No, Your Honor, thank you.
Thank you. On the record, in the matter of the people of the state of Michigan versus Oak of Barksdale, file number 24-00972. Parents.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Barksdale, who's standing to my right.
Okay, how are you, Mr. Barksdale?
I'm good, how are you?
I'm well, and this is Oak of Barksdale the third, correct?
Yes.
Okay, today is the date that was scheduled for preliminary examination, and there's a request to adjourn.
That's correct, Your Honor. The people be requesting a cause adjournment. The two witnesses on this case are both officers, and they were both also, one of them was actually the officer who we previously discussed, was called into an investigation. Both of the officers for this case were called into to handle that investigation in an interview.
So, just so we're clear, my understanding is that there was some incident in the city of Lansing either late this night, early this morning. And they're still there?
That's my understanding, Your Honor.
Counsel, how do you want to proceed?
Your Honor, we will not object to the prosecution's request to adjourn.
I was gonna grant it anyways because it's outside of our control and they're just gonna reissue the charge. I just, obviously, she wouldn't know. I don't understand why they're still there. They're not at court, if they have court cases.
I would prefer they were here as well, Your Honor. But
The court's gonna grant the request because, again, it's not in the interest of judicial economy to dismiss it just for them to go right down the street and reissue it against you. Then you gotta be rearranged. And we don't know, your bond was 7,510% when Magistrate Milmore arranged you then, but they could be different the next time. We don't know. And so with that being stated, we're going to find good cause to go beyond the 21 days so that we can reset this, okay? All right. June 21st at 9 a.m.
Your Honor, can we possibly do it a different day? I believe we're going to be off on that Friday.
Someone approved you to have vacation?
It hasn't been approved yet. I have to put in the request.
Do June 28th at 9. You still be on vacation June 28th?
Yep.
June 28th at 9. Okay, any additional matters for the record?
nothing from the people.
Nothing from the defense yet.
We'll get you your notice to appear and you're all set, okay? Thank you.